Interim order is expiring today. Who is your other side? 2 p.m. Why? 2 p.m. Why?
But a young lawyer.
Yes, there is probability of a resolution.
1:15.
My lord, item number 96. May I have my lord's kindly mentioned? My lord has better at length.
Item number
96. My lord,
Yes.
we are suffering, my lord, every day. My lord, there is an eviction decree passed, traveled up to Supreme Court, decree is upheld. Now, my lord, the judgment debtor, my lord, he files an application under section 47 saying that, my lord, the decree is without jurisdiction and all. My lord has heard the other side.
Yes, let me see how far
Well,
I can
there is-
proceed today.
well, there is a Supreme Court direction, well, which says that within 4 months, well, this has to be well, disposed of. Now, since my lord has granted them liberty to well, pray for an adjournment for a day, well, showing that order every day they are asking for
What
adjournment
is the
and
next
getting
date
it.
fixed?
Next date coming. 28th of this month.
28th. Already please mention on Monday.
Wait.
Yes.
My lord, may I, my lord, permitted to mention, my lord, item number 197 of the days list, my lord.
For what?
My lord, for the difficulties, my lord. And
What do you want?
my lord, for
Upgradation supplementary, it's not possible, Mr. Vance. Please wait. Please mention on Monday. Please mention on Monday.
Have your lordships.
তুমি
Yes, what is the urgency? 17th. What will be carried out? Demolition of your house. Why? Under what provision? Notice under which provision? Under which section? Section 10 is not public land. Section 10, sir, is not public land. Is it a notice under section 10(1)? Please go through that. Yes. Let me see how far I can proceed. Yes.
65, my lord.
Yes.
Has been, my lord, found guilty and by the Internal Complaint Committee under the Post Act. My 30 days period expires on Monday.
Mr. Bordon, upgradation is.
Then
Please let me see how far I can proceed.
Then Monday.
Your
So
Lord-
30 days period will expire.
Let me see. Yes.
Your Lordship, item number 39 of today's list, my lord. It is my section 47 under
The number?
39, my lord.
Yes.
Your Lordship, my section 47 under CPC has been dismissed, Your Lordship, and execution has been expedited. Next date is on 19th August, Your Lordship.
Let me see. Yes.
My lord,
May
can
I-
it be on Monday,
Yes.
my lord?
May I have your lordships very kind leave to very urgent mention an urgent matter of Justice Partho Sarothi Sen. Your lordship, this matter was listed today for extension of interim order. As
Yes.
item number 14, the interim order is expiring today. If my lord
Who is
kindly
the other
takes,
side? Who is
Your lordship, the
appealing for
other
the
side
other?
is PWD. I will give a notice. I will give a notice, my lord. I am mentioning upon. I will give a notice again.
You are appearing.
No, your lordship. Nilanjan Bhattacharya is appearing on the other side.
I will give a notice, my lord.
All right. Please come at 1:15.
Grateful, my lord. Grateful.
Sir, may I mention?
Please furnish these particulars.
Sir, may
Yes.
I mention one extremely urgent matter from determination of Honorable Justice Sen, my lord. A proceeding under 62 Act. We are at the appellate stage. Now, my lord, glaring
Banerjee, you cannot wait for a day.
cannot. Tuesday is the date fixed. On the previous day, we prayed for stay. Court said, the appellate authority said stay is rejected without giving any reason and proceeding with the appeal. So,
What is the next date fixed?
Tuesday, this Tuesday, 18th. Monday kindly takes up, my lord.
Monday.
Monday.
All right. Monday. Monday.
As kindly to mention, Lord, I'm praying for filing of a revisional application without the certified copy. Lord, we have the authority serves by email. That is the procedure they follow. But this otherwise is an appealable order. We preferred the appeal, but there is no chairperson, so the appeal is adjourned to September. In the meantime, the returnable date has come where they have asked me to pay penalty in the event. I do not know. There's
File it.
urgency is next date is 20th.
Yes.
For compliance, if it could appear on Monday.
What is the item number? All right, please mention on Monday.
Monday or Tuesday, any day.
Yes. Who is appearing for the other side? Please bring him. Please supply the particulars. Please bring him. Give notice.
Item number 51, my lord.
হ্যাঁ রেগুলার বেঞ্চে রেখে দিই তারপর yes entry order is expiring when all right please supply the particulars. Please inform the other side.
Item number 15, my lord.
Please come at 1. Monday is the eviction date. All right, let it be evicted. Thereafter, you will be reinstated.
Item number 51, the bank has taken
Yes.
possession. The bank has taken possession yesterday. Yesterday sought to mention, my lord. Now sale certificate has been issued, my lord. They'll sell the property. I'm mentioning about.
No, my lord, I am the bank. My lord, first of all, civil division application is not maintainable. Second, I have taken possession,
It's item
given,
number. What is the item?
given it to somebody.
See how far I can
for
proceed
action
today.
purchase.
Yes.
কি বললো?
Yes. 10-1. 10-1. Then there is no urgency. Sir, have you gone through? Sir, have you gone through the provisions of section 10? All the subsections. 10-1. Then what will be done after 10-1? Sir, please go through the provisions. Yes. Call the next matter. Withdrawal. Please use the microphone. What is the urgency? You cannot wait for a day. শোনা যাচ্ছে না? Please use the microphone, sir.
My lord, 10th June, they published a notice, my lord, and the petitioner is resided more than 50 years in the quarters, my
No
lord.
urgency.
My lord,
Yes.
anytime they can evict the petitioner
yes.
from the, and then they also,
Lordship, my award has been stayed after 4 years of filing the execution, telling that the appointment of arbitrators was not good. My next date is on 18th.
Please mention on Monday. Yes, call the list.
Yes. In item number 1, I am appealing for the petitioner. This
my
matter
lord, I appear on behalf of the
in
opposite
practice.
party.
Yes, why it is to be mentioned?
Yes, my lord, this for the non-prosecution. My lord, this
Oh, you
application
don't want
has
to
been of
proceed.
pretty
The learned advocate appeals. Yes.
Lord, the custody application, Lord. Till 31st March 2026, the minor child, my lord, 5 year.
No, why it is to be mentioned, Mr. Ghosh?
instruction with regard to mediation. They were supposed to come back.
Why to be mentioned?
My lord, yes, this is not, because question of jurisdiction is involved. Lord.
Oh, this is that matter.
Whether mediation will happen or not, nothing on merit.
No, this is not a case of mediation. It's that matter where the child has been taken. Are you ready, Mr.
And April, my lord, the
You are
file
appearing for the
application
opposite
is
party.
judge.
Yes, when do you want?
Whenever your lordship pleases. But if I'm not mistaken, my lord, have a look to your lordship's last order. That's why to be mentioned.
No,
No,
Last order.
yes,
Last order is accommodation sought for by the learned advocate for the opposite.
10th of July.
10th of July.
There is no question of mediation. I have
তো তোরা তো আগের দিন বললি তো পেঁচা ছিল তখন বললো
Mediation, no mediation. There was no mediation.
Kindly have a look at it. Mr. Rai, learned advocate appearing for the opposite party on instruction submits that the, I'm sorry. Instructions from his client. Mother will be free to meet the child. Would that be it? Amicable settlement? Yes. Huh? Yes. Second paragraph, learned senior advocate appearing for the petitioner prays for an accommodation to take instruction from his client.
No, Mr. Chatterjee.
Yes, that's the first paragraph, my lord. Your lordship made that observation.
What?
First
Amicable
paragraph.
settlement.
Yes.
So, has it been settled?
My lord, they wanted to see the child.
That's not an amicable settlement, Mr. Chatterjee. That was
Then,
interim during the pendency.
then what does Mr. Ghosh want, my lord? If he can communicate to me, then I can take instruction.
Mr. Chatterjee, it was communicated when this matter was taken up. An accommodation has been sought for by the then learned advocate.
There was no communication from them at all.
Nothing. Then I can proceed it on merits.
There are instances.
Then it's better to proceed it on merits
Yes,
Yes.
because
আচ্ছা ঠিক আছে
সোমবার না,
শুনানি করে দেখি অসুবিধা আছে?
তারপরে
otherwise, Lord,
In view of Mr. Chatterjee also concede করো
no.
রাইট জজ
Yeah,
এটা বলে
yeah.
তুমি যা ইচ্ছে তাই করো। তাই তো এই
issues are not same, Mr. Chatterjee.
issue
So no analogous.
can never be same.
No analogous.
Can never be same. That's what I'm saying.
মানডে উইক করো না মানডে
আমার অসুবিধা
মানডে
তুমি বলবে for the petitioner. Interim order is expiring on 17th. The lordship,
Who is appearing for the opposite party?
since the inception your lordship have served, they have not appeared.
They have not appeared. What is the impugned order?
You order your lordship, my amendment application has been rejected. I am a plaintiff landlord for rejectment.
Your amendment application has been rejected. Amendment of what? Plaint or written statement?
I'm the plaintiff landlord in an eviction.
Yes, what is the amendment sought for?
What I've tried to incorporate in my claim is that during pendency of the suit, I've taken possession of two other rooms of the suit premises by evicting and separate tenant. Now I want to incorporate that fact that I've taken possession of two rooms in the ground floor. Now since there is a ground of reasonable requirement in this suit, that is prima facie required to adjudicate since there is a ground of reasonable requirement. Lordship will find my application at page 41. Lordship.
No one appeared for the opposite party.
The beginning, Your Lordship, I've served twice. Even I've served again, Your Lordship.
This is from which court?
Small cause. Presidency small cause.
Who is the learned advocate appearing for the opposite party?
The learned advocate who is appearing is Advocate HON'BLE. Now, but he is not the advocate on record as I have been instructed. The advocate on record is someone from Calcutta. Now, I have previously mailed conducting advocate, Your Lordship, the difficulty the advocate on record does not.
I'm passing it over, or I'm making it not today. Interim order is still which date?
7th. We keep it on Monday. Your Lordship.
I'm keeping it on Monday. Please serve a notice upon the learned advocate appearing for the opposite party. I'm keeping it on Monday.
Only difficulty is, Your Lordship, the advocate who is appearing.
Please use the microphone.
The advocate who is appearing in the also who is arguing the matter is from the bar of small cause, but he's not the advocate on record, is not receiving notice.
Is not receiving the notice.
Not
Please make an attempt, then I will consider. File an affidavit of service stating all the facts, then if that is so, I can take it upon merits. None appears for the
Your Lordship, one thing I have already served regarding today, not on the party. The opposite party had served regarding to this date. The matter will be appearing this date, that I have served.
No. I've said advocate representing the opposite party. You need not serve the opposite party again. Yes. Who is appearing for the opposite party? Have you served the notice upon him? When? What is the impugned order? None appears.
My appearing for extension of the interim order
Yes.
and arising out of an order passed by the Honorable NCLT.
এই কিছু নেই, শুধু order sheet
Order is expiring on Monday.
the interim
Blood.
order is
We have the opposite party.
citing this interim order, they are praying for adjournments in the main matter. The interim order is only for perjury stay.
I hope this is incorrect.
No proceed.
Because Millard,
Mr. Dashgupta.
I had clarified it.
Please make that submission
No,
before
Millard,
that forum.
all I'm praying for, I have a different prayer.
I'm only extending the interim order which was.
No, Millard, I have a slightly different prayer, Millard.
Yes.
If having regard to the immense pressure that your lordship faces, if it could be taken up on a day, it's a very short issue, Millard. Because otherwise, Millard, that is the only prayer I make before I
The learned advocate.
extended it.
Of December end.
December. Millard, this is an insolvency proceeding that they are holding up. So that's a time-bound matter, Millard.
It was interim order was passed. It was extended from time to time. Yes.
Very well. Wait.
Who is appearing? None appears for the petitioner at the time of call. No. What do you want?
Hearing of the ending of 19.
What is the stage of the suit?
Thereafter, they deferred on
Where are the order sheets? You have not annexed the order sheets. Where is the order sheet? This is the copy of the evidence. Where is the order sheet? Is that the order sheet or is that copy of the deposition? This application under Article 227 of the Constitution of India is at the instance
from same one.
frame. This application under Article 227 of the Constitution.
Should I for the petition? Pendants are petitioned before your lordship by the order in which lordship the learned advocates commissioner's report was accepted. Challenging that I am coming up before your lordship. Now here.
The revisable order, Mr. Chakraborty. Acceptance of commissioner's report. How can it be a revisable order? Because that's already part of the evidence, forms part of the evidence.
Considers this. Here what happened, lordship? There is a dispute regarding the cost schedule property. Plaintiff is saying that cost schedule property is within his property. The defendants are saying that cost schedule property is within their property. Now, lordship, order 26 rule 9 was filed. Lordship kindly sees the
Show me the plaint.
plaintiff at page 12.
Page
12. Lordship will kindly come page 17. And the next page is the type copy of page 17, lordship.
So your declaration that's cost schedule forms part of cost schedule.
Yes,
So that's the declaration.
yes. Regarding co, whether it is within their property or
Whether
by-
it's part of core or not.
Yes. And now lordship will kindly come to their order 26 rule 9. That is at page 36.
Yes.
And lordship, the schedule lordship, that is at page 37.
Yes.
The তফসিল is নালিশি পরিদর্শন করিয়া 1934 সালের এত নম্বর দলিল খ তফসিল সম্পত্তির মধ্যে চৌহদ্দি রিলে করিয়া and RS হাল দাগ হিসেবে প্রদর্শিত হচ্ছে তদমর্মে রিপোর্ট দিতে হয় to compare with the deed, their deed. So lordship, accordingly lordship, the first report was submitted that is at page 40. I challenge that lordship. Now the learned trial judge at page lordship 48, lordship will kindly come. The third last paragraph. Now at page 48, my lord. Now on perusal of the commissioner's report and considering of the established principle of survey, I found some discrepancy in respect of relaying fixed point in the same. Accordingly, learned investigation commissioner is hereby directed to conduct the local investigation again and to submit the report by ascertaining two fixed points in two different directions. So very specific direction was given. Now again the learned commissioner goes lordship, that again submits a report that is at page 49. Lordship kindly comes to page 49. In the last paragraph he mentions that the learned judge was pleased to direct the commissioner to detect the second fixed point in order to verify the location of CS tag number such and such for confirmation of the report dated such and such. It was not for confirmation, to make it again. Lordship kindly sees the earlier page and to submit the report.
All right, where is the commissioner's report?
Yes. Lordship will kindly come. That is at page 49.
Page?
49, Lordship is
Yes.
page 50. In the middle paragraph, Lordship kindly sees the last line and it may be treated as fixed point, no dispute. So he fixes 1 point. Now Lordship kindly sees the entire Lordship report. The second point is not fixed. Is earlier report.
Did you cross-examine the commissioner?
63. Further examination in chief.
Yes.
8th line, Lordship. 7th, 8th line. I have not identified to fix point in two different directions to conduct the local investigation again. Then says, I have clarified the same in my report. Then after a few lines, Lordship, I have not seen the deed dated such and such of 1934 at the time of my commission work for the second time when I submitted my report. Voluntarily says there was no necessity to pursue the said deed.
Check the commissioner's report.
No, Lordship,
Please
this
see order 26 rule 10(2).
CPC টা আনিস না কেন?
You have not got. You want the hard copy? দিন। এটা দিন তো। Order 26, right at page 10(2), subsection 2.
The report of the commissioner and the evidence taken by him, not the evidence without proper, shall be evidence in the suit and shall form part of the record. But the
So
court,
automatically,
yes,
when a commission is held, now and the report along with the evidence, that forms part of the record and it is an evidence in the suit. So once it is, statute says it's an evidence, it cannot be rejected.
but Lordship, then the commissioner has to be directed, Lordship, to do it again according to the earlier order.
So it cannot be rejected. Commissioner's report cannot be rejected, but 10(3) can be invoked.
Yes.
10(3) could have been, because commissioner's report cannot be rejected in that way. Ashun.
The Lordship petitioner challenged the order of alimony passed by the first additional district and session judge, Paschim Mednipur.
Yes.
My lord, alimony penalty upon application under section first 24. Thereafter, the husband petitioner in the instant title suit, my lord, matrimonial suit, find amendment application under section under the provision of Special Marriage Act. Their
Application for alimony penalty rejected.
my lord.
On what ground?
On ground that the wife petitioner is here, my lord, was the previously married wife, and she is divorcee. But instead of that, she suppressed that she obtained 4 lakhs rupees from the previous husband at the time of divorce. On that sole ground, my lord, and due to suppress of that material fact, my lord, the order was rejected. My lord, kindly come to page 2 to 9, second volume, my lord. The opposite party husband is an employee of TCS Bangalore, and instead of order directed to the husband to submit the salary slip, she did not submit the same. And 2 to 9, my lord, second volume.
The learned advocate appearing for the
Expedient disposal of my application for police help. What is happened? There is an injunction, my lord, that was not been implemented. I lodged a complaint, I filed, put a petition along with the application. My lord, that was not been initially, my lord, accepted. But subsequently, it was accepted, my lord, but no, my lord, the date not fixed, my lord. My application for police help be taken up for hearing as well as my lord, pay for my expedient disposal of the suit, my lord. I am the plaintiff.
when the order of injunction was passed.
Thereafter, I lodged a complaint on 24th of September 2025. The order of injunction.
Summons not served.
No, ad interim order, 12th of November.
Ad interim order you need not serve.
No, what is it, sir?
How can an ad interim order of injunction be implemented to police help?
Order 12th of November 2025, 2024, the order was passed with regard to status, with regard to property.
This serves, then I will consider.
They are making erecting construction about the said property by violating the order. I served the copy, my lord, upon the other side. Kindly see the order, my lord.
Where have you served?
They are appeared. They paid for time to WS.
Please show me that.
Well, kindly see the last order, my lord. On order dated 2nd of February 2026, 25 application for
7th of February 2026.
Yes.
Yes.
Thereafter, my lord, the dependent number 1 filed a petition praying for adjournment on the ground stated therein had considered Paris allowed cases adjourned to 25th of September to 25th of June 2024 filing WSWO.
Your injunction is against whom?
Against the defendant number 1.
Against the defendant number 1.
12th of November.
Where is that?
Order number 2.
No, not defendant number 1. All the defendants.
They have been served, my lord. They are not filing, my lord. We are
certified. Why are you saying only against the defendant number 1?
Defendant number 1 is the more appeared, my lord.
So that's different. That's neither here nor there. This application under Article 227. Yes, next.
Be explained. Be explained.
Could not follow. Yes.
Be explained.
Suit. Service not completed. Suit expedited. You have got more than what you deserve. So don't proceed further. Yes, Mr. Bannerjee.
Lord, I am for the defendant petitioner. Sued by the plaintiff, Lord, is he's a member of a cooperative society against the other members and post holders of a cooperative society. He has filed a suit for declaration for share and documents. We are 2C2D. We entered appearance and filed a maintainability petition saying that 102 subsection 4 there is a clear bar. Dispute between member and other members of society or post holder, no suit will lie. The petition, Lord, was kept pending. On 25th of March, the date was fixed. The advocate on record, she appeared in the morning and filed a put up and said that my application for maintainability be heard first in the morning. Then she left, expecting that the date shall be fixed. In the second of the matter was again called on. And the court passed an order that nobody is present. Show cause why it shall not be heard ex parte. Show cause file, reply to the show cause file. It was said that I was there in the morning. I thought that matter has been heard, so I left. On the next date, court takes up the matter, doesn't consider my reply to show cause, but considers my application for extension of time to file WS and fix the matter ex parte. Now, the explanation given in the extension application was that because of lawyer's personal difficulty, could not prepare the WS, kindly extend the time for filing WS. Now it is ready. But court will not record that no, it's a big society, so she cannot file, so matter is fixed ex parte. This is absolutely absolute irregularity, and the petition for showing show cause was not considered at all. I'll kindly take up this order sheet once, Millard. the previous orders. Kindly take up, my lord. Point of view. On 25th of March 26, my lord, I filed Hajira. Lordship will find I am 2C 2D. The fourth line says that defendant number 2C and 2D files Hajira. Then plaintiff files written objection against the petition on maintainability. They file order 14 rule 2. They should have filed order 7 rule 11. They have filed order 14 rule 2. None appeared on behalf of defendant 2C 2D. It was taken up in the second half. So show cause. Very well. Then I filed the show cause. Then the impugned order comes. My show cause is not at page 37. If your lordship once not sees page 37, paragraph 2, that on that day, upon mentioning your honor was pleased to take out the record of the case and hear both sides when the advocate for the applicant asked to fix up a date for hearing of the application filed by the defendant after hearing the learned advocate for the applicant. Left the court on understanding that the court will fix a date. Maybe a mistake, wrong understanding matter was again taken up. I am not on that. But I explained this. Now kindly come to the impugned order. Nothing considered. 29th of June. And one more document, my lord. Page 40. Page 40, my lord, lordship kindly sees.
When the summons was served, Mr. Banerjee,
Summons was served, my lord, on 3rd of November 2025.
3rd of November.
No. I entered appearance on 3rd November. I entered appearance on 3rd of
3rd November 2025.
I entered appearance. It is out of time. I am not saying that WS, it is ready, my lord. So my petition was, prayer was at page 40 for extension of time.
Page 46.
Page 40 is my application for extension of time, that as the learned advocate for the defendant, due to her personal difficulty, could not prepare the written statement, it is not possible
for it ground, Mr. Banerjee.
We have paid for extension of time, my lord. The court now kindly sees this petition is not considered. Court is saying that kindly see what is the reason recorded. Court has not considered my application for extension, has not considered my reply to show cause. Kindly see what court says. 29th of June. None appeared on behalf of the defendant number 1, 2A, 2B. Advocate for defendant number 2, 2C, 2D has submitted that representing a housing society consisting of many members.
So the order dated 29th of June is under challenge.
Under challenge. 29th of June.
So 29th of June, you have again directed to file show cause.
No, 29th of
show cause, I direct the trial court to decide.
No. 29th of June. In view of the above aspect, the show cause application is hereby rejected.
Yes.
Consequently, instant suit will be heard ex parte against defendant number 2, 2C, 2D. Now, my show, where did the court consider?
No, then next line.
Due to non-taking of step, defendant 1, 2,
and the other defendants.
Other set of defendants. So, the court did not consider my application. Your lordship has seen my explanation. I said that I appeared and I moved the matter. Where is the consideration of my application? The suit itself is not maintainable, my lord. Hit by section 102.4. Lordship kindly sees once, my lord. 102.4. We shall take this point subsequently. Kindly sees once, my lord.
Mr.
Absolute bar, my lord.
Mr. Banerjee, learned advocate appearing for the Give me a minute.
This is the order passed in an appeal preferred by the state of West Bengal.
So this is the order passed in the execution case.
They did not pay the amount. That is why the execution proceeding is going on, my lord. Now, my lord, in the last occasion, the judgment debtor prays for time. They are delaying the entire proceedings. Kindly give a direction to the judgment debtor to pay the amount, to deposit the amount with the court.
Evening.
What do you want now?
Let the amount, the decretal amount, be deposited with the court, and
So
the
that direction has been passed by the learned trial judge. Why are you angry?
in spite of that, they did not pay the amount. The proceeding is going on, and they're paying the.
For that attachment and other things, please proceed there. What
Well,
can be
let-
done here?
Well, let at least give a direction to the learned executing court to complete the proceedings within a stipulated period of time, and deposited the amount to the court.
Mr. Chatterjee, learned advocate. Yes.
Similar to that of the 14.
Similar to that of
14 in the earlier matter.
here also no order has been passed. No,
Only the matter is pending before the
এটা ওই শুধু এলএ কেস নাম্বারটা হবে
Item number 16, my lord, Mr. Sixth Shah is appearing for the petitioner, my lord. He is suffering from fever, my lord. He has gone to doctor's chamber. My lord, kindly fix any day in the next week, my lord.
what is this matter?
The revision against the judgment of the appeal court in the preemption matter.
Injunction. Injunction.
No injunction.
Preemption.
Preemption.
Who are you?
My lord, I am the PMT, my lord. Lord, next week fixed any day, my lord.
Trial court dismissed the preemption case.
First court allowed and second appeal court dismissed my appeal. Against that order, I prefer this revision.
What is the ground of challenge? What is the ground of challenge?
But, let Mr. Dotto, let Mr. Saha argue the matter, my lord. He is suffering.
Which Mr. Shah?
Dev Dotto Saha, my lord. He is suffering from fever, my lord.
An accommodation has been sought. ওই প্রথম ম্যাটারটা ওই লাস্ট অর্ডারের আগের অর্ডারটাতে আছে।
Number 79 for the petitioner, your lordship, for an expeditious disposal of a matter of a title suit, your lordship, which is pending since 2014, your lordship.
2000
2014. Your lordship, may I please appraise the court on 8th of
what have you done?
The orders, your lordship. My petition is only about 9 to 10 pages. And the certified copies.
What is the miss case for?
Miss case for your lordship, the pro forma defendant has filed the miss case under
Order 39, Rule 2A, Your Lordship. After a joint petition was also filed, there are two defendants, Your Lordship. Now the defendant number 2 has filed this miss case, which is still pending, and they are also means they are taking time and adjournments, and pending since 2017. They have filed in the May
Where are
2007.
the subsequent orders after 2019? Where are the orders?
Your Lordship, kindly come to volume 2, Your Lordship. As far as I can locate, Your Lordship, the order number is order number 74. They have marked. After that, there is no order number. So after that also there are several orders in which the resolution was there, and simultaneously for the multiplicity of the means there are proceedings. This title suit is also pending, and meanwhile this miscase is also pending. So my prayer is only for the expeditious disposal of the matters, Your Lordship, or at least for the title suit. And this miscase is meritless, Your Lordship. It is just because of the harassment of this title suit and to delay the proceedings of the title suit. And that too, they are taking time over there. It is pending in the evidence stage, Your Lordship, from 2017, and now it's August 2026. In the meanwhile, Your Lordship, there was a joint petition filed. There was amicably
The suit, the evidence started, no?
in the
In the
title
title
suit.
suit.
Yes, Your Lordship. The title suit was about to in the
The
final stage.
151 application has been disposed of in the suit.
Yes, Your Lordship.
When it was disposed of?
No, 151 application is not being disposed of, Your
What is the
Lordship.
151 for? What is the prayer in the 151 application?
Your Lordship, that I have to collect the instruction, Your Lordship. I don't have at right now, Your Lordship.
It's application under Article 227 of the
Your Lordship, Mr. Orunava Bhattacharya is appearing in this matter. For some personal difficulty, he has not yet reached the court. Kindly keep it up on in the second half, Your Lordship.
On the prayer of the learned advocate for the petitioner,
So I have committed some mistake. So the order impugned is order dated 30th January 2026 is an appealable order.
order impugned is 30th of January. Injunction. The learned advocate appearing for the petitioner. Yes.
Worship, the matter is for expeditious disposal of lower court proceeding, being title suit number 1207 of 2019. The matter is Lordship. Plaintiff filed a declaration suit for a flat, which is also claimed by the defendant number 4. Thereafter, Lordship, injunction application filed and injunction order passed on 9/12/2019. That is Lordship,
Subsection
case
on
number
Article 227 of the Constitution of India.
But filed by different parties and claim is also same. Declaration suit. Two matter, lordship, what is happened? Plaintiff number in two matter, both plaintiffs filed to purchase two flats, and the developer has already sold those two flats to another person. One flat owner filed previous matter, and another flat owner filed this matter.
This application on Article 227 of
I am for the petitioner. I am for the decree holder, opposite part. A suit for eviction was filed, my lord. Suit for eviction was filed against the petitioner herein being the tenant. Now, on the reasonable ground, decree was passed, but against the petitioner herein. The petitioner preferred appeal. Appeal was admitted and also filed an application for stay. But application for stay has been rejected, my lord. The petitioner, my lord, is residing in the house from 1987, and the opposite party purchased the house with the petitioner herein, my lord, as a tenant.
yes, Mr. Mukherjee.
I say, my lord, the reasoning so far as regards the imposition, kindly see what point we have urged. We urged if the stay is being granted, we are entitled to occupation charges. That they have contested, they suggested that this should be, my lord, without payment of any
Where is
occupation
that?
charge. Kindly see, my lord, the order impute. Kindly see.
Yes.
My lord, kindly see the second paragraph of the first page. It has been submitted. Has your lordship got it, my lord?
Yes.
It has been submitted by the learned advocate for the respondent landlord that if the court deems it fit to grant stay, the same is to be made subject to payment of occupation charge at the market rate at rate of rupees 15,000 per month from the date of passing of the judgment and decree against the appellant. In terms of the written objection, he has prayed that any order of stay, impugned judgment and decree be granted only on such condition. That was my submission. He has relied upon the judgment I am not on. Kindly see now, thus the last paragraph. Thus heard the both side.
Yes.
Now, kindly see, I have kindly see. He has also relied upon the decision of the Atmaram properties, the above portion. Atmaram properties limited to submit that scrutiny and order of stay, merely preferring an appeal is not statutory right conferred upon the appellant according to him, without the judgment are being quoted. Thus, heard both sides, peruse the stay petition as well as the written objection filed by the respective parties on record, and also the certified copy of the judgment and decree as filed on record. Considering all, on perusal of the stay petition itself, it appears that the appellant has simpliciter asked the court to stay the impugned order and decree till the disposal appeal solely on the grounds of appeal being filed. There is no other grounds shown in the stay petition granting the stay. So all along, Lord, my submission before the appellate court is that if you grant an order of stay, the occupation charge has to be increased. Why? The property is, my lord, it's 2 bedroom, 1 storeroom, 1 veranda, 1 kitchen at premises, my lord, it's Belghoria. So, my lord, I prayed for occupation charge. Your lordship here and now, my lord, grant stay till disposal of the appeal. But considering Belghoria, such a property is being enjoyed by.
We are paying 1,100.
1,100
per month. We are paying. As
That's the market rate in that locality.
But now,
please get a similar accommodation in that. Please vacate. Please vacate. You can get less than that. Why you will pay more?
15,000. 15,000. He paid for 15,000. Kindly consider this because 15,000.
According to you, is the market rate.
But the market rate, as you lordship, please, kindly 15,000. 1,100 he is paying. But seriously, in view of the judgment, petitioner is liable to pay. Liable to pay the occupational charges, my lord, as a lordship, my lord, as your lordship.
But I am asking you, what is the market rate?
Market, my lord, there will be 3,000.
3,000 you will be getting. All right, please vacate. 3,000 you did not pay 3,000 to the
15,000, my lord.
Don't pay anything more than the market rate. Please vacate. Get an alternative accommodation.
As your lordship, please.
I'm coming after 5 minutes. Please take instructions. What is the market rate? Please take instructions. If you get at that figure, I will also consider. If my estimation is higher, please you can vacate. I am submitting. I'm coming after 5 minutes. Please take instructions and come. What is your instruction?
Instruction is this, this is one bedroom and one small room, means 2 bedroom, one kitchen and one veranda. But this is the Bilgori area where I also resides, big area. But I took instruction that there would be maximum 5,000 rupees per month, because the 5,000 rupees per month, because the room, this 2 room,
5,000 rupees per month is the market rate.
Market rate. But because I am paying 1,100. But I am here.
You are paying, forget about that. What you are paying as per the contractual rate, forget about that.
And the whole area is one kata. They are in building constructed. Now can you realize there may not be more than 500 square feet. With 1 bedroom, one small room, and one veranda is there. So
Mr. Mukherjee, please show me the decree.
Decree. And they have started execution case also. They have started execution case, madam.
They are not entitled to do so.
No, yes. I am to praise your lordship.
And Milord, it's under Belghoria police station. I leave it to your lordship. Milord, I already considered that when an appeal is being filed, Milord, there has to be a stay, but it has to be a conditional. I leave it to your lordship.
What is according to you the market
Milord,
rate?
15,000 that I have, Milord, already.
You have stated anywhere. Where is that?
Kindly takes up my written objection. Page 21. Page 20 it starts. Page 21, paragraph 6.
Any written objection or rejoinder to this?
No.
Yes, what do you say? You have not.
I have suggested that, Milord, nothing, Milord.
What is
When
there?
the decree was passed.
It is decree passed, Milord, in February, I believe.
February
2026.
Yes, ma'am. February 2026.
And Milord, the first paragraph of the order impugned, my lord would get the stand of the Milord judgment debtor that he is, Milord, entitled to, Milord, obtain a
So
stay.
that was the
Submission.
of his counterpart.
That's why,
It's not his submission. He knows very well that occupation charges are to be paid.
Yes,
That's the stand before the trial. That's before the appellate.
Has to be given. Occupation has to be given. But there, the quantum, my learned friend, asked to give, my lord, 15,000. But in my area, my lord, this is not. But I can safely say, my lord, I can safely say this. Where I reside in this, but as you know, I am leaving it to lordship. I am leaving it to lordship.
Your lordships leave me.
This application under Article 227 of the Constitution
But for area, but just make it 1 month
How
more.
much it comes?
But it will come February, March, April, May, June, July, August.
50,000.
70,000. It will come 60,000.
March, April, May, June, July, 5 months.
5 months.
50,000.
But
Not 70,000 you can pay within that.
But he's a small source, my lord. He's a
Yes,
very,
yes. Next, call the next matter. Yes.
23, my lord, I appear on behalf of the petitioner.
Hey, unconditional stay. One thing, Mr. Rai, unconditional stay would be
That is, my lord, if my lord.
Ruby Singh was the presiding officer who heard in part.
Yes, my lord.
Now the presiding officer is Shoma Chakraborty.
If some precedence may be given, my lord, some precedence may be given.
What precedence?
Lord, let the injunction application be heard out. My lord.
This application under Article 227 of the Constitution of
Wait, please, your lordship.
Yes.
This is under Article 27 of the Constitution of India, my lord. For expeditious disposal of an pending application, my lord. For
Expeditious disposal of?
disposal of the pending application, my lord, in connection
What is
with
the
the
pending application?
Lord, that is for expunging, my lord. That was, my lord, kindly have a look at straightway, my lord, to my lord, order number 61. Before
Expunging
one
of what?
Of the name of one of the plaintiff and two defendants, my lord. One defendant and one plaintiff.
Where is the application? Have you annexed that?
That application, I'm saying, Lord, that application was heard since 1 year, my lord. Now the order has not yet been passed, and on the last date, my lord, 11th August was the date fixed for passing the order, and again the order
For expunging the name of the plaintiff number 8 and the defendant number 9.
Yes, yes.
This application under Article 227 of the Constitution
For
of India
1 year, it is, my lord, for lying.
is that
Rejected. Suit
Order 6 Rule 17 was
rejected.
Plaintiff's application.
Plaintiff's application to incorporate further relief of recovery of possession. Because defendant admitted in the written statement that since the possession has been taken, so in view of that, paragraph number 15D, which is appearing at page 28.
Page
28.
28.
Paragraph D. The defendant said that they have taken possession
Paragraph
D. That was the subject matter of the property. Along with the registered conveyance, I have challenged because it is on base of the false personification of ownership. Not only to incorporate the further relief. My amendment application is just after the certified copy of the impugned order. Prayer for recovery of possession. Page 16 is the prayer in the plain.
The learned advocate appealing for the petitioner may be justified.
My lord, praying for expeditious disposal of the title suit, which is going on since 2016. Meanwhile, the defendant number, I am the widow of the defendant number 2. The defendant number 2 died while contesting the suit. I, being the widow, praying for this expeditious disposal, my lord. Currently, DW1 is going on.
Expeditious disposal of the suit.
Of the title suit, my lord.
Have you taken steps for service upon the substituted defendants?
Yes, my lord.
When have you taken steps?
My lord, I am the defendant. I am the widow of the defendant, actual defendant. I have already entered appearance by giving a fresh wakalatnama.
When you have entered appearance?
27/10/2025, my lord.
This application under Article 220.
Petition by the husband and the wife, my lord, for waiving of the 6 months, my lord, period. My lord has passed a order, my lord, earlier in one of my cases, my lord. Kindly see the order, my lord. My lord, 7 years of, my lord, litigation is they are settling it, my lord. They have withdrawn the divorce suit, my lord. They have filed joint compromise petition, my lord. 498A. My lord, this is the, my lord, my lord's order, my lord. earlier order, my lord, in a different suit, my lord.
Have you brought this judgment? Civil appeal number 801 of 2026. Misha Somani versus Rituraj Somani.
Yes, ma'am.
Where is that? Please show me.
My lord, there are other judgments, my lord, which are there, my lord. My
No,
lord,
other judgments are there.
Akashdeep Singh, my lord. Amardeep Singh, sorry.
No. Misha Somani and Rituraj Somani. Where is that?
May I?
Which was relied upon by the learned trial judge. Where is that?
My lord, that judgment, my lord, is my lord, it's not there. My lord. Give me, my lord, Passover, my lord, I'll bring it, my lord.
All it.
A short Passover, my lord.
Passover next.
Nothing.
Please, Your Lordship, I beg to appear on behalf of the petitioner in a DRT proceeding. Petitioner, my lord, is the bank, so it is not an appealable order.
The bank?
Petitioner is the bank.
Section is the bank.
14, yes. Section 14, my lord, he is with me. Section 14, my lord, disposed of.
You are standing here.
No,
I thought that you were opposite.
That's exactly why I made that submission that he's with me. There is no other sir.
Yes.
Now, my lord, what happens is the borrower has taken loan of about 53 crores. He set up the tenant, and the tenant is going and saying that I am in possession. I will not, my lord, as usual, my lord, whatever happens. We are in a position to show, my lord, that the tenancy happened after the mortgage. That the DRT has to, my lord, even come to a specific finding before grant of stay. Now, here what has happened is, Section 14 initially was filed, my lord, in 2021 once. The order allowed, order did not allow, order rather stayed it. We came up before this honorable court. From then, my lord, the writ petition is pending, not touched by the High Court.
Which petition is pending?
The writ petition, challenging the order under Section 14. Now, my lord, what happens is there is another Section 14 which we have filed, where, my lord, we wanted to take possession because, my lord, 53.
So, Chatterjee, then earlier Section 14 is pending.
Yes, but this is a fresh cause of action. We've given a fresh notice and a fresh cause of action.
Might be, but
can do that.
It's not that you are not entitled to do that on a subsequent event. But the question is the same thing, because
Well,
it's
the
not a
question is
not a subsequent event.
No.
So once you find that one of your attempt to take possession, yes, so that's been stayed. You issue another notice and you.
Yes, my lord. I am on a very fundamental submission before your lordship, where, my lord, if there is
that Section 40, that writ petition was filed by you.
By me.
So now why have filed 227 now?
My lord, because I have a right.
There also you had a right.
I had a right here also. There is no, my lord.
The Chatterjee, only one thing. If one Section 14 by the
Lord,
same
may I
bank
play for this? Very
arising out of a same proceeding
very
was
well.
filed in 226,
Very well.
another
May I do this?
227.
May I do
not
this?
forum shopping, Mr. Chatterjee?
No. What I'm trying to do, I'm saying today this, my lord, that I will, my lord, pray before my lord Justice Rai to get that released and get it assigned before your lordship. Both the matters can be heard
On the
together.
other hand, I can release that.
No, my lord, it will never be
Why?
difficult. That is my choice. That, my lord,
that's one part. Second, Mr. Chatterjee, whether 226 and 227 are both maintainable.
Yes.
Or one of that is maintainable.
No, my lord, it's a choice that I can have.
But
It's a choice that the litigant has.
What's the nature of the order under
Same
Section 14?
thing. Same
What
thing.
is the nature of the order under Section 14?
Now, writ of certiorari, my lord, gives the right, whatever your lordship knows better than me.
The list of certiorari. So now can you say that no, I can come in?
I can.
27?
I can. My lord, there is nothing which takes it out. With a lot of respect.
Because This is
There is nothing in law which
something-
bars a
two
constitutional
things
remedy.
I'm telling you, this proceedings as well as in PP Act proceedings.
My lord,
Some orders challenged in 226, same parties, another order challenged in 227.
can be done. Can be done. It is not that it can't be done. What should be done is, even if 226 and 227 now, it should be heard by the honorable same judge. That Miller, I will make that submission. But your lordship can't, Miller, can always say, my respectful submission is a constitutional remedy. That's also a constitutional remedy. This is also a constitutional.
So there's some distinction between
There is-
your RI and
Miller,
227.
may I make this submission? The Supreme Court now has said that even a trial court's order can be challenged in certiorari. Justice Khare's judgment, of course. Justice Khare's judgment.
When
I'll give it to your lordship.
19 says different thing.
No, writ of certiorari, even a trial. I'm sorry, never a no, Miller. Writ of certiorari is given in a situation where, my lord, it is completely beyond jurisdiction. The trial court jurisdiction is not there. Writ of certiorari lies. Justice Khare's judgment, my lord, goes further and says even an order which is wrong, there a writ of certiorari lies as well. But that's a separate aspect. 227 is a given thing. That's a constitutional powers given to a
Both are
constitutional.
constitutional power.
Yes, yes.
So both
Avenues might be a little different, but at the same time, my lord, I can challenge. It's my, my lord, election. What I will do. It is the election of the, my lord, the litigant where he wants to go. This is a, my lord, in a way a legal fiction, but a legal fiction supported by law.
Otherwise, one thing, this will give rise to forum shopping. Mr.
It
Chairman.
can give rise, but if you do not limit it, and if the right is there, Miller, in my respectful submission, I can't be stopped from exploring my right. You can't.
Against the.
Lords can do anything, but my respectful submission, Miller, a constitutional right cannot be abridged. Cannot be. It is tried, my lord, that it should be heard by the same judge. That is why the assignment. That is why, my lord, both matters should come before your lordship and your lordship disposes them off. I don't have a problem at all. But today, my lord, kindly see what's happening. In this matter, because there is a writ petition pending, the trial court doesn't want to hear it.
The tribunal.
Yes.
How can, if there is a.
There is no order of stay.
That, Mr. Chatterjee, it's up to you. You have to apprise the Planet Tribunal that can be taken up.
I have apprised it. I have told the learned judge that look here, there is no stay. That whatever is there, I can always forego that as well. I don't have to, my lord, run after that. I'm running after this. Hear this out. Today, if the tenant wants a stay, he has to pay. He can't, my lord, stay there.
Order.
Kindly have a look at the impugned order.
Page.
Right at the beginning, my lord, your lordship will find.
Right at the beginning, sometimes in the middle, sometimes at the end.
Just
difficult.
Just after the, my lord, the index. Nowadays, my lords have asked us to do this.
So because this was at times placed in the middle.
In the middle or something.
Because previously, once I come, I go to the last page. Then I do not find
it there.
Then
that's
we have
why
to
habit, and then your lordship gets back to reality. Have a look at it, Miller. It was all there. It was all there. Lordship,
What happened, Mr. Chatterjee? Any resolution?
UPM Miller is a very young human, 28-year-old. He was the junior of Mr. Dolapati, and he's Miller, the worst part is about the parents. He's a lawyer of Shialda Court. Miller,
the father.
And he lost his elder son, Miller, about 2 or 3 years back. It's unbelievable.
He was also an advocate.
He was not an advocate. Unbelievable situation. I was saying Shialda High Court. So today, my lord, what happens is, he says you can take possession of a showroom of about 6,000 square feet, where, my lord, there's a running, my lord, bike, super bike being sold from there. So it's impossible for me to take possession of even an inch. Forget about selling.
The earlier section 14 was 3rd September 2021.
Yes. Yes. They said that tenants.
Pending from 2021.
Yes, my lord. What happens is, I don't want to say, but it is reality. The file is not to be found. It's reality. File is not to be found even today. Why I've come up before your lordship is one of those reasons. Is one of those reasons.
So this matter is not appearing. You said that it's appearing before the other bench.
No, no, it's not appearing. It was pending. I said it's pending. Not appearing, because the file is not traceable.
For that, you have to take steps, Mr. Chatterjee.
Milord, we've taken every step possible. It's the bank's money, it's public's money, Milord. 53 crores these humans have taken.
There is no caveat.
No, I have
Serve
to
a
serve.
copy in the meantime.
Milord directs me to serve both. Even that writ petition and lordship, kindly, Milord.
Writ petition, Mr. Chatterjee.
Of course, the writ petition is served on them. They know that.
I do not have determination with
Milord,
regard to
well,
that
I'll take
petition.
steps on that. I'll take steps on that. In the meantime, allow me to serve and come. The certiorari judgment, Milord.
IA 753 of 2026 is
this one.
Yes, is against what? Order passed in section 14, rejecting section 14.
Yes. Yes.
The order
allowing section 14 part.
Allowing section 14 part.
That order, my lord, of the CGM, your lordship will find at page 81, the ordering portion.
Only 81?
Yes, my lord, only.
Something before the no.
No, I'm sorry. 185. There are two markings.
Cannot be only two figures.
I'm sorry, my lord, it was allowed completely. 185. It was allowed, my lord, totally. The earlier order was in part.
This is allowed in totally.
Totally.
Now the tenant has challenged.
Yes, yes.
Tenant has challenged.
Yes.
And tenancy 10,000.
185.
185. That's the ordering portion. Have a look at it below. 6,555 square feet, super built up area in ideal center. On job land, Milord, is about 1 bigha and odd.
The order challenging the order dated 20th of February 2026, passed by the Chief Judicial Magistrate, Calcutta, on an application under section 14 of the SURFACE Act, comma, the opposite party number?
1.
The opposite party number 1 filed an IA, filed IA number 752 of 2026 in SA 119 of 2026.
No, yes.
SA 119 of 2026. Full stop. By an order dated 10th of March 2026.
No, there's one mistake, Lord. The section 14, the section 17 was filed by 3 and 4.
No, I have not said who has filed the section 17.
4 and 5.
I have said section 14 order.
Section 14 was filed.
I have said the order passed in section 14 has been challenged by opposite party number 1 in IA.
No, 3 and 4.
Said 1.
1, Milord, is the original borrower.
By 1 এর জায়গা না ওটা 3 and 4. 3 and
it's 4 and 5.
They are the tenants. 3 and 4 by filing IA number such and such.
That is correct.
SA number such and such. Full stop. By an order dated 10th of March 2026, the debts recovery tribunal uh, which DRT?
DRT, there's one.
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 DRT one. Directed the petitioner bank to obtain final orders in the writ petition being WPA 17217 of 2021, which is pending before this court. Mr. Petitioner is directed to serve a copy of this civil division application upon the opposite parties and file an affidavit of service on the next date. Motion September monthly list.
Possible to fix a date, my lord.
Please get it other matters, otherwise.
I'll do that in the meantime.
Do that. Yes, next.
Acha, once you let it appear, my lord, I'll mention.
Yes. Please wait. Yes, scholar expert.
Petitioner before your lordship challenging the order passed by the Land Civil Judge Junior Division Additional Court Krishnagar Nodia, whereby the petitioner filed an application and order rule 17 rejected, my lordship. Your petitioner preferred to correct the date of the deeds, my lordship, that 45.
Where is the schedule of amendment? Where is the amendment application?
Amendment application I filed, my lordship. Page 54, my lordship.
54?
54.
Post title pleading prayer portion.
My lord.
Post title what to be changed?
Post title, no, post title should not be changed. That means, my lordship, the only amendment prayed for one A and B to for wrong dates of the deed, my lordship. Deed number same, and delete the schedule B. Petitioner prays for declaration in respect of schedule A, B, and C.
Where is the plaint?
Plaint, my lordship. Page 45. Page 45, para 2 and 3.
In favor of Bhagavati Ghosh. Bhagavati Ghosh's name is not mentioned in paragraph 2.
Paragraph 2, my lordship, that the
paragraph 3.
Paragraph 2, the deed should be same. Only the date.
Paragraph 3 of the plaintiff shall deed in favor of the plaintiff shall be correctly. Paragraph
50 deed number. 6350 dated should
dated as 3544 dated. It's confusing the amendment. Paragraph 2, there is no mention of the name of Bhagavati Ghosh. Paragraph 2 of the plaintiff. Paragraph 3, you have said it's the deed of the plaintiff.
Deed of the plaintiff. In paragraph number 2, the sale deed number 6350, The deed should be same, but dated should be imported, my lordship.
But paragraph 2, it's not. Paragraph 2 is confusing. Paragraph 2 is confusing. B schedule. What is B schedule?
My lordship, Bhagavati Ghosh, the name of the Bhagavati Ghosh is there, paragraph number 2, my lordship.
Paragraph 2.
Paragraph 2. The
Where
plaintiff,
is the name of Bhagavati Ghosh?
Bhagavati Ghosh, my lordship,
Land to Bhagavati Ghosh.
1, 2, 3, 4 line of
Prima facie appears to this court that the yes. Yes, where is that judgment?
My lord, this Misha Somani also, my lord, relied on Amit Kumar, my lord. My lord, kindly cease.
Yes. What it says?
My lord, page 2, my lord, kindly cease. Starting from where it is where there is a chance of reconciliation, however slight, the cooling off period of 6 months from the date of filing of the divorce petition should be enforced. However, if there is no possibility of reconciliation, it would be meaningless to prolong the agony of the parties to the marriage. Thus,
So this order has been passed under 142. This cannot be done here.
no, my lord, this my lord, Amit Kumar versus
Yes.
Suman Beniwal, this order is relying on Amit Kumar. My lord, kindly seize Amit Kumar. My lord, first page, my lord, kindly 3, my lord. This 142 for this, my lord, but the ratio decidendi is, my lord, that when there is a prolongment of agony, my lord, 6 months should be, my lord, waived off. My lord, I have the Amit Kumar judgment, my lord. This is the judgment, this is relied on. I have Amardeep Singh also, ache na? Amardeep Singh is there.
Right, please give me this judgments. Please come on Monday. Ashwin. Heard the learned advocates for the part.
The one thing, my lord, speak to Karimal and compelling circumstances, my lord. My lord, after 2 p.m., my lord, we have the Bar Association has taken a resolution not to attend, my lord, due to sudden death of one of our young member. My lord, my item number 37. I am just, my lord, leaving the court in my eye treatment. So your lordship, as your lordship desire, my lord. Item number
Up to you. I have nothing to say. What you say? Yes, call the supplementary list. Yes.
Now, if nobody appear, my lord, your lordship not dismiss the matter default or otherwise. Well, as your lordship desire.
Yes.
May I be permitted to mention on urgent matter courtroom number 19, lordship. The interim order will expire on 18th of this month, lordship.
Then file the.
My lord, may I be permitted to mention on extremely urgent matter, my lord?
Matter has been called on and you are mentioning. Please maintain some decorum, sir.
I'm appearing for the railway authority.
Extension of interim order. So can you see the last
Yes.
paragraph? Lead matter, all our matter lots, a bunch of matter lots, interim order extend till November and hard on 26 August.
Yes. What is the next date fixed?
Till November, the interim order expire until November, and in between also lead matter, only 4 lead matter, your lordship, hard on 26 August. And interim order till November.
All the
There's a 125. November. Order has not been uploaded yet. Last order. No, wait.
Yes. Interim order is extended till
November and all matter appearing on 26 August.
26th of August.
Yes, sir.
There is
Swine evict. That is their approach, lordship.
that I know.
No, my lord.
You are protected.
Not at all.
You are happy with that.
All right, lordship, protected till November at least. Their approach like this, lordship. There is no mention for November, but I will evict those shop, lordship. Same, next matter is same also.
This is also same.
Same, lordship.
This is also same. We একই order করে দিন. Yes, next.
Lordship, but they are not.
My lord, I mentioned this matter in the morning. Your lordship, the interim order is expiring today. Against an order of demolition. Kindly have a look at the order. Against the order of demolition under the
Demolition by whom?
Highway.
Demolition by whom?
West Bengal Highways Authority. Under section 10.
Where is the
Page 2. My lord.
page
2, last paragraph.
What is the challenge in this petition?
Challenge is, your lordship, an order passed by the SDM for removing the boundary wall, which they say as an obstruction, relying upon the order passed by the district magistrate in 2023. Your lordship, the appellate authority against this order is the district magistrate only. So I cannot go before the same district magistrate who has already passed an order.
No,
I was not a party to that proceeding.
Where is the order passed under section 10(3)?
Yes, your lordship. Lordship will take the writ petition if your lordship has the writ petition.
134.
Yes, my lord, 130.
134 is not by the district magistrate.
No, but
It's
kindly see.
sub-divisional magistrate.
No, paragraph 2, he refers to the order of the district magistrate already 2023 in a proceeding where I was not a party. where an order is passed by the then district magistrate on 28th April 2023 in compliance of with the solemn direction passed in the matter of Ardhendu Nak and such and such. This was a PIL file. In that PIL, the district magistrate, upon reconsideration, passed an order that this should be evicted. I was not a party to that. On the basis of that, this order has been passed. So I cannot go before the same authority who has already passed an order of eviction.
You cannot also come before the single bench also.
But
because the division bench, it was in compliance with the order of the division bench.
No, I was not a party there. I am on the issue.
You are not a party there. If you can take that point in 10.4 also. So if you say you cannot go there, you cannot also apply the same logic. You cannot also come here.
That was passed in a PIL.
Yes. So
in an eviction drive.
according to you, since an order was passed in a PIL and the district magistrate in compliance with that passed certain orders, you cannot prefer an appeal to the district magistrate under 10.4. Applying the same logic, you cannot come before the single bench.
Kindly see, this eviction order has been passed by the SDM. Against that,
Yes.
the only authority is district magistrate.
Yes.
It's already passed an order.
That is what I am saying. If you say that you cannot go before the district magistrate, because I also cannot bypass the order of the division bench. That's also binding.
The division bench order does not relate to my case. That was in an eviction drive which does not relate to my property.
That is the logic. You can approach 10.4 before the district magistrate. Take this point there.
Kindly, I cannot do that. Why I say so?
Why?
Why I say so, my lord? This was
Either way, you are in a fix.
No,
If you say that you cannot go there, then you cannot come before the single
Your
bench.
lordship, kindly give me some time. Your lordship, the order of the district magistrate in 2023 was in respect of an eviction drive
Who
initiated
is
by a
opposing you?
person,
Who is opposing you?
PWD. Who is there?
Yes, you are appearing.
Yes, Lordship.
What do you say?
Lordship, I don't have brief, Lordship. Only I got this letter, Lordship.
The copy has not been served.
Yes, she was there on the last when the interim order was passed. Kindly see. She was there. She was there.
This is extension of interim order.
Oh, Lordship, let me check.
Your lordship, here the principles of Caesar versus
when you are
Caesar will
flooded-
apply.
Lordship, I have just run away. Lordship,
Flooded
kindly
with
give-
briefs, you
Your lordship, here the principle of Caesar versus Caesar will apply. Your lordship, person who has already passed an order, I cannot go because he cannot act as the appellate authority. And your lordship, in the PIL,
you cannot bypass the order passed by
your
the
lordship, the
division
order of
in a
division
PIL.
bench does not say that the eviction order should be passed against my client. It's a PIL file making allegation that there are certain illegal construction on both the sides of the M bypass. On the basis of that, the matter was remanded to DM. DM said that, okay, I am passing order for eviction without giving me any opportunity of hearing. I was not a party to that. Subsequently, the SDM has passed an order saying that I will go on 6th of August and demolish the boundary wall. So I have challenged that order of the SDM before the read court because I have nowhere to go then. Because the moment I approach the DM, he will say that I have already passed an order. How can I entertain your cause? He will be a judge of his own cause. So that's why I come up in writ.
Lordship, this matter is leading by senior standing counsel.
It's only for extension.
On that day, Lordship, I appeared
From
on behalf
4th of August till 14th, you could not move before the regular bench.
No, I have moved. No, your lordship. The regular bench was not there. That's why I moved before the bench taking up the urgent matter. That's otherwise I would have moved the regular bench. Today the matter was kept by the regular bench for extension.
This matter was I have again clarified.
That they will take anyways. Grateful.
Yes. Next. Yes, call the next matter.
Lordship.
Item number 4 and 5.
Yes.
This is for extension of interim order. These are my applications.
Yes.
Item number 5.
extended till August 18.
Yes,
is
Your
there.
Lordship.
So
No, this is for extension because it is expiring on 18th. Your
yes,
Lordship.
so 17th you have, I have determination only for this day.
Lordship,
Since the
same matter. Yes, Your
same order. Next.
Monday is the eviction date, Lordship. Yes.
What is this?
Railway hawkers, Lordship. Last page, page 33. Within 7
Page?
days, 33. Within 7 days, Monday is expired on 7 days. Second paragraph.
Yes, what are the orders passed now?
Lead matter is hearing, Lordship, on 26 August, and all matter interim order till November, Lordship.
What is the latest interim order passed by the
এই অর্ডারটা দেখো, এটা till নভেম্বর, একই অর্ডার।
নভেম্বরটা বার করে রাখো।
অনেকটা আছে।
রেগুলারাইজ করি। চালাতে পারবো না। না, যতগুলোতে দাঁড়িয়েছি সবাই অন্যদেরকে তারপরে লাভ নেই না।
Representative capacity also allowed.
This is which railway station?
Bidhannagar station. Bidhannagar. Oh, this is Pairajanga. Pairajanga railway station. And here's the one order till November, Lordship. The bunch of matter, some of the matter uploaded, some of not yet. Needs to be uploaded.
How many petitioners are there?
Lordship, only 3 or 4.
Court fees?
By 10 minutes, Lordship. Within 10 minutes, Lordship, I'll pay.
Within 10 minutes? Why have you not filed with the
No, Lordship.
entire court fees?
At the time of
Whatever.
filing, they're not accepted.
In the deficit court fees, then I'm keeping it on
Within
Monday.
10 minutes, Lordship. Lordship, kindly, Lordship. Within 10 minutes, Lordship. 10 minutes.
You have filed with the proper court fees.
Lordship.
Whatever.
Lordship, court fees is not
We are
available.
taking a
Lordship.
chance.
Court fees is not available. Lordship, we'll
On the prayer of the learned
Is my appointment, my lord. High lordship, can you regularize her name?
ওনার অ্যাপয়েন্টমেন্টটা আর কিছু না। Yes, where is your other side?
Lordship, I'm led by Mr. Avinash Kankani, Lordship. Led by Mr. Avinash Kankani.
Yes.
He is not able today.
Today, my lord, kindly extend. Last order, kindly 16 July 2026.
The in the morning.
Lordship, I got the information after sitting.
What can be done? 2 p.m. it can be taken up.
Lordship, I
18th.
18th.
Mentioned on Monday.
My lord, I'm sorry for my lord the travel I have caused earlier, my lord. But may I be permitted to mention, my lord, one extremely urgent matter for my lord Kotum number 19. The house of the petitioners will be demolished, my lord, on my lord 18th.
18th.
Yes, my lord. On
17th it can appear. List is better on 17th.
Taken up on 2 p.m. This is, my lord.
Electricity is a different aspect altogether. Electricity is not under group 1.
My lord.
So for electricity you have to take steps. এটা রেগুলার বেঞ্চে এই 17 তারিখে
Keep your
Appear for the opposite party, your lordship. I have filed my wakalatnama.
Who is appearing for the petitioner?
My lord, we have not been served in this matter yet. We were not on caveat. We have not been served in this matter yet, but we filed a wakalatnama.
Over. Next.
I am for the petitioner, my lord. For same set of facts, my lord, I have got a earlier order, my lord. My lord, someone has been served through registered post on 4th of July 2025 and appeared on 18th July and filed application under 7.1 and 7.2 on 31st July. My lord, no, I have denied the service to belief. Court, my lord, held that only 2 orders are there, my lord.
Where is your application under section 7.2?
My lord, 7.2 application, my lord. I'm telling. Seven to page 33. Page 33. Lord, here, my lord, it has been stated that on 18 July appeared. And my lord, this matter has been, my lord, mentioned in, my lord, page 41. An application under 151 was filed. Page 41, your lordship will find that he has denied the service. Filed a miss case 151, there it has been stated.
Yes, you have put the signature on the ID card.
No, well, that has been denied. That has been disputed.
Merely denying will not help, Mr.
No, no, that order 5 rule 17 says that, my lord, unless the belief is examined and my lord in support of that affidavit is filed, my lord, that service, my lord, if disputed, that cannot be, my lord.
Raise that at the time of final hearing. If you succeed, it will go.
No, my lord, kindly see
Merely by saying no, I have not received, that will not do. That will not do. Wherever disputed that is not your signature, please show me. You have not stated anywhere.
My lord, in the 7
You have not stated anywhere.
7 application, my lord, it has not been clearly stated, my lord. My lord,
You have not clearly stated end of the matter.
No, my lord, what is the law, my lord? He has
show me in 151 you have stated that.
Yes,
Please
yes.
show me.
My lord, page 44, page 41, page 41. Page 41, my lord, the petitioner is an innocent person regarding, page 41, second paragraph 11. The petitioner defendant is an innocent person regarding the respective laws and only postal summon has been received by the petitioner and no summon was served upon the petitioner through court by the process server of the learned court as per knowledge of the petitioner defendant. So, well, this is to be decided without, my lord, examining the person and without evidence, my lord, this cannot be. And my lord, same parties, my lord, we have got a same set of facts. Your lordship passed order in respect of 2.
That might be. All matters that creates the disbelief.
Party same, my lord.
Maybe party same.
Yes.
Maybe party same.
No,
So you are taking the same plea in
no.
all matters, postal slip.
No, I have not, my lord.
You have not disputed
my
that
lord,
that signature appearing in the ID card is not your signature.
I say
You
that,
have not
my lord,
stated that.
let the examination be made. Made the 7-2 application.
You prove that by way of examination. Nobody is stopping you.
My lord,
this will not be satisfied.
7th has been
you
allowed.
Prove that, Mr. Chakraborty, you prove that it was not been served.
No, my
then
lord.
you can pray for
If
equality.
7th allowed, my lord, and 7 to dispose of, there is no scope to adduce evidence.
You can challenge that, service everything. You can cross-examine the plaintiff's witness. Succeed in that.
My lord, my signature, my lord, I am to, my lord, place, my lord, I am to, my lord, prove my document. My signature will be, my lord, I say examine. So, my lord,
examine that.
No, my lord,
in all matters, this cannot be the plea.
No, all matters, my lord, three petition, three suits have been
You have
filed.
not stated anything with regard to that service to the process server. You are silent.
My lord,
you have not said that that
my lord,
signature is not
actually,
your
my
signature.
lord, this is the mishandlement of the, my lord.
Show me that in the civil revision application you have disputed that.
My lord,
You show me on oath you have stated that that is not the, from here I will send it, and if it is found for stating false statement, he will have to face the consequences.
No, my lord,
show me that you have stated that in the civil revision application.
Yes.
If
My lord,
you want, I will give you leave to file a supplementary affidavit. Please make that point on oath. Then I will see.
my lord, kindly see
Here
paragraph.
and now I will send that to the.
My lord, kindly see paragraph 7.
Yes.
The learned my civil revision.
Please first.
The learned court below without examining the belief and without examining.
But you have not stated that that's not your signature.
No, my lord, kindly see or plaintiff believed upon the report of the process server holding that the summon has been allegedly served upon the defendant by process server.
Have you inspected the record?
And also,
Mr. Chakraborty, have you inspected the record? Then how do you know that it has not been served upon you?
My
It
lord,
does not bear your signature.
My lord, once, my lord, whatever appearing from this application under section 151, on basis of that I am saying it has been stated.
That you cannot do. Once you are disputing, your materials are on record.
So kindly see that.
Unless you have inspected the records, unless you have seen that signature, you cannot dispute.
Defendant file an application, my lord, kindly see, I have stated that no summon has been served upon the dependent through process server, and summon was served upon the dependent by post on 4th of July 2025, and the application under 7.1 has been filed within the prescribed period, but the court below rejected the application under 151 and also under 7.2 of the original constitution. The application, this is also, my lord, this is to be
Mr.
judged.
Chakraborty, only one thing, without inspecting the records, without inspecting the signature on the AD card, how can you say that that's not your signature?
So
My question to you is that.
So, my lord, that is to be, my lord, adjudged, my lord, that is to be, my lord, the signature is to be verified. It is to be, my lord, proved. Signature.
File a supplementary affidavit, state that it's not your signature. What is appearing in the AD card, in that document, process server. Then I will call for the documents. I will, from here and now, I will send that to the examiner.
No, what is there, my lord?
So Chakraborty, that is very easy to take this plea.
No, I am not.
You have not verified the records, and you are saying, putting the blame.
No,
Yes,
my lord,
let them.
My lord, what is stated in the
But
application?
this 7.2 for service of summons,
My lord,
they will have to bring these postal peon
My
and
lord,
other things for evidence.
my lord, I have, my lord, this application under 151 has been stated on oath, and on basis of that,
What you have stated on note that the signature on that document is not yours. Where is that? Please show me.
my lord, I have stated that on, my lord, by post he has been served.
So postal articles have been served. That's please show me where have you stated that the in the process servers your signature is not there. Please show me. You are silent on that. You have not stated on oath with regard to that anywhere.
Then, my lord, if your lordship so says, my lord, then I am to, my lord, ask my client to.
Please look at those documents, whether it's your signature, your client's signature or not. Otherwise, it's very risky to say. You are stating those. It's very difficult.
My lord, let the matter be, my lord, let the matter be, notice be given, other side let me come, other side come.
Why? What is the necessity?
My lord, nothing will happen. He will come within 1 month, and matter will be heard in presence of both parties, my lord.
No stay then. No stay.
No, that
No
will not.
stay.
The 7th has been allowed, my lord. Can you see? So, if not.
Now it will move at rocket speed. Suit will not.
That's why, my
Yes, yes.
That's why we have been compelled, my lord. Otherwise,
You have taken this risk.
Look, kindly
You have,
my lord, kindly see.
you have taken time to file that application. You have taken that risk.
First order suit file. Second order you have appeared, and third order is my lord, rejection of the. Look, kindly see within a
Second
span.
order or third order is neither here nor there. You have to comply with those within the time.
Look, kindly see, my lord, my lord, it has been held as 27 days delay, but my lord, it has been posted on 4th July, and it appeared and appeared on 18 and 31st file. So for the postal service, my lord, well within the time. Well within the time. My lord, kindly consider the consequence, my lord. If, my lord, it is not their case that, my lord, the defendant was, my lord, playing with the court and several. My, lord, kindly see, my lord, this is consequence, my lord, kindly see. The legislature has been made with some, my lord, protection.
Chakraborty, learned advocate, appearing for the petitioner submits
Same set of facts, my lord, suit number is different.
Same thing.
Same thing, suit number, same, my lord.
How many matters of same thing?
Total, my lord, actually three suits, six application has been filed, three against 7 ones, 3 against 7 two. Suit number is different, my lord. This is suit number different.
Same order. Yes.
Well, kindly say the suit number is different.
Suit number ta dekhen. Yes, next.
Same.
35.
Suit number টা দেখেন, suit number. Suit number গুলো different আছে কিন্তু। দেখি নোট করে রাখেন। একই।
36
suit number গুলো different।
35 পর্যন্ত একই সেম, শুধু suit number টি চেঞ্জ। Yes, 36. Pass over next. Pass over.
38, my lord, I'm appearing for the petitioner, expeditious disposal. It is a suit for eviction. 2017 suit was filed. My lord, they have the defendant appeared in 2022. Though they have appeared in 22, they have given the WS. It was accepted. My lord, thereafter evidence has been started of PW1. PW1 completed. Thereafter, they have filed an application for amendment. That is also allowed. I'm accepted that. I had not filed any objection to that. Till date, the matter is pending for evidence. And nowadays, there is no PO.
Cross-examination of PW1.
My lord, cross-examination has been completed. Thereafter, amendment of WS.
Now a date is fixed for further cross-examination of PW1.
PW1.
This application under Article 227.
My lord, after coming 6 months, my lord.
30, 37 ki holo? 38. Yes.
Your Lordship, I am for the opposite party. I am led by Mr.
There is no
Purus
caveat, Your
Bandyopadhyay.
Lordship. This is appearing for the first
I
time. There is
am
no
appearing
caveat.
seeing the list. So this is an execution petition. They have dragged till 10 years. There is no urgency, Your Lordship.
There is urgency, Your
Yeah,
Lordship.
they have taken 50 adjournments on a circle.
May I, my lord? This is my
My
application.
humble prayer will be kindly fix it on Monday.
Yes, what is this matter?
Your Lordship, my application has been filed under 47 of the CPC, Your Lordship. I am the award debtor, Your Lordship. It has been rejected on the ground that I have not availed the remedy under Section 34 of the Arbitration and Conciliation Act, Your Lordship.
Yes. What is the ground under section 47?
Your Lordship, I have to say that it is a nullity. In this
Why-
case,
why
my
it's
lord,
a nullity?
my lord, what has happened is this award has been passed by the MSAB Council, Your Lordship. Now, the person concerned who was appointed as the conciliator, Your Lordship, he is the same person who is also there in the arbitration panel, my lord. And he was also the arbitrator, which according to me, my lord, under the provisions of Arbitration and Conciliation Act, my lord, it is not permissible.
Why did not take that point when the arbitration proceeding was continuing? Why did not take that point when the arbitration proceedings was continuing?
Your
Why you
Lordship,
shall be allowed to take this point now?
Your
But this
Lordship,
hearing, they have taken 60
Sir,
adjournments.
you are not posted with the facts. You don't have the copy.
I don't know.
If you are ready, I can take it up.
Your Lordship.
Quiet. Yes.
Your Lordship, at that point of time, the person who was there, he appeared in person, my lord.
That's neither here nor there.
Your
He
Lord-
chose to appear in person at that point
Your
of time.
Lordship, but a nullity point can be taken at this stage, my lord. Kindly considers. Kindly does not.
Do you have any decision in your support that the same person cannot act as an arbitrator? Where is the bar?
Your Lordship, the point had been taken before the Honorable Supreme Court of India, my lord, the Tamil Nadu Cements, where, my lord, the issue has been taken into consideration. It has been referred to larger bench, my lord. May I hand over?
It has been referred to larger bench. So issue
My
has
lord.
not yet been decided.
Your Lordship, it refers to two judgments, my lord, which are contrary. One judgment which says that the conciliation and arbitration proceedings cannot be clubbed, my lord. May I hand over a copy of that? And your Lordship, my section 47 also could not have been set aside on the ground that I have not availed the provisions under section 34, my lord. I have a judgment on that issue also.
Arbitration conciliation একটা আছে দেখুন তো arbitration conciliation act. What is the order which you are challenging? What is the date of the order which you are challenging?
18th May 2026, your Lordship. It was heard on 14th
18th
May
May
2026.
2026. Yes.
It is annexed at the end of the petition, your Lordship. Your Lordship, kindly takes internal page.
Give me a minute. Please give me a minute.
Your Lordship, may I refer to the statutory provisions, my Lord?
Tamil Nadu Cement says which paragraph you want?
Your Lordship, paragraph 64, my Lord. The issue that has
Paragraph?
been raised. 64, my Lord. The issue that has been raised, my Lord.
Yes.
My Lord, also may I refer to the statutory provisions, my Lord. Kindly takes up the MSME Act, Your Lordship. Section 18, subsection 4.
You have a MSME Act.
Yes, Your Lordship.
You have another act, no?
No, Your Lordship.
আমাদের MSME Act আছে, দেখুন তো। আছে? Section?
Section 18, subsection 4.
Yes.
Your Lordship kindly refers to this, my Lord, that what happens is once the conciliation is done, the MSME Council can take up the arbitration or refer it to a different center, but the provisions of the Arbitration and Conciliation Act shall apply. Now, my Lord, in consonance with this, if Your Lordship kindly takes up Section 80 of the Arbitration and Conciliation Act.
80 of the Arbitration and Conciliation Act.
Yes, Your Lordship.
Yes.
Role of conciliator in other proceedings. May I, my Lord? Unless otherwise agreed by the parties, the conciliator shall not act as an arbitrator or as a representative or counsel of a party in any arbitral or judicial proceeding in respect of a dispute that is the subject matter of conciliation proceedings. The conciliator shall not be presented by the parties as a witness in any arbitral or judicial proceedings. My Lord,
Here what happened? The conciliation failed.
The conciliation failed. The conciliator who was there.
Conciliation failed. Why? The parties did not appear.
no, parties appeared, parties did not agree on the settlement, my lord, and then the conciliation failed. The person who was the conciliator is also there in the arbitration panel. There were arbitration panel of 4 members, my lord. One of the members was the conciliator.
Yes.
On this issue, my lord, we had filed an application under section 14 of the Code of Civil Procedure, your lordship. One of the points, one of the reasonings by virtue of which my section 47 was also rejected, my lord, was that we had not availed our remedy under section 34, my lord. My application under section 47 is not contingent upon me filing an application under section 34. For that also, your lordship, may I rely upon a judgment, my lord?
Yes, which paragraph?
Paragraph 64, my lord. Paragraph 64 onwards, your lordship. This order came to be challenged by the appellant before the High Court in a proceeding under 227 of the Constitution of India. We have already noted 3 issues framed by the High Court for consideration. Insofar as the first issue is concerned, the High Court is of the view that an award can be challenged in a proceeding under Section 47 on the very limited ground of the award being a nullity or void ab initio or suffering from inherent lack of jurisdiction. However, the High Court opined that if an aggrieved party does not challenge an award under Section 34, it cannot be permitted to object to its execution by alleging it to be nullity, though such a plea of nullity can be entertained if it is of such a grave nature that it is not even capable of being waived by one or the other party. Therefore, the High Court concluded that the plea of nullity qua an arbitral award can be raised in a proceeding under Section 47, but such a challenge would lie within a very narrow compass. Insofar as my lord, then it is with regards to another issue. Your lordship, then paragraph 69. Section 47 deals with questions to be determined by the court executing decree as per section 1. All questions arising between the parties to the suit in which the decree was passed and relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Execution of decrees and orders is provided for in Order 21. The law is well settled that at the stage of execution, an objection as to the executability of the decree can be raised, but such an objection is limited to the ground of jurisdictional infirmity or voidness. The law laid down by this court in Vasudev Dhanjibhai Modi versus Rajabhai Abdul Rahman is that only a decree which is a nullity can be a subject matter of objection under 47 and not one which is erroneous either in law or on facts. Objection to execution of an award under Section 47 CPC is not dependent or contingent upon filing a petition under Section 34 of the 1996 Act. The High Court was not justified in taking the view that since the appellant did not file a petition under Section 34 of the 1996 Act, therefore it was precluded from filing an application before the executing court to declare that the award as void and hence non-executable.
Yes. Yes.
Well,
When it is fixed before the
19th August. 19th August, your lordship.
19th of August.
And your lordship, by this order also, the execution matter has been expedited. We are not coming in the way of that, my lord. But because, my lord, we are challenging this rejection of Section 47, my lord, which is why.
Here, give him a copy. I'm taking it up, fixing it on Monday.
Grateful, my lord.
Ashwin. The taken your MSME Act.
Your Lordship.
MSME Act you have taken back.
Yes, yes, Your Lordship. I've taken.
Yes.
Monday relatively at the top, my lord, Your Lordship, kind of. On Monday relatively at the top, if Your Lordship can.
Yes, yes. Next.
Well, let me take your lordship. Very short matter, my lord. I am for the plaintiff petitioner. It's a suit for declaration injunction. Now, my lord, after completion of meeting the matter, my lord, posted for my lord, the witness action of PW1. Now, my lord, the PW1, my lord, is also the power of attorney holder of the other plaintiffs. Now, she is a lawyer and a resident of United Kingdom. Now, my lord, the application was made for my lord, taking evidence by way of video conferencing. Now, my lord, the rule of our High Court also tells my lord, that there is no embargo to do that. Now, my lord, rejecting that, my lord, the impugned order is passed. My lord, just one page. My lord, kindly have a look at that. It's my lord, 11th May 2026. Now, my lord, may I place it, my lord? Today is fixed for passing order in respect of petition such and such. The plaintiff has filed the instant petition stating plaintiff number 3 is a registered power holder and looking after the case and who is herself a legal practitioner in England. As such, it is not possible for her to appear for deposing the court for which she intends to depose through video conference. Defendant opposes this prayer, stating that plaintiff number 3 deposed on dock in Miss case number such and such, and she is avoiding to face cross-examination in the instant suit. Heard the learned advocates both sides peruse the case. There is specially a ground for non-appearance in this court is mentioned that she is a legal practitioner in England for which she is not in a position to attend this court for deposing. The version is opposed by the defendant stating that defendant number 3 attended in court to depose Miss case in such and such. Now, my lord, she appeared, but it was adjourned on that day. On careful perusal of the materials on record, this court observes that the ground of non-appearance in court to depose is not strong enough. But I have to give a strong reason. Moreover, there are other plaintiffs too who can depose in this suit. But its carriage of proceeding lies with me. It's me to choose. Plaintiff does not disclose any special knowledge of plaintiff number 3 regarding cause of action. The plaintiff number 3 has no physical ailment or any other obstacle for which she is not in a position to attend the court to depose. Nothing evidence through vital mode is extremely exceptional matter for which there must be a strong ground which is absent here and the petition is to be rejected. So, what are 2 points, Malad? I am a practicing lawyer, Malad, that is not a ground. And I have to have, Malad, a physical element or, Malad, a strong ground. What is the strong ground? I don't know. Now, Malad, I have
But
also
you deposed in the miscellaneous case in person.
Yes,
When?
Malad, I tell
Is
you,
what
Lordship,
date?
the order is there. Malad, in the last page, maybe. Malad, kindly. Documents? No, the Miss case is not there. On that day, I appeared.
Yes.
If evidence, Malad, on that day it was adjourned.
Yes.
I have to go back to England.
It just happened to be there. On which date?
It's
On which date you appeared in person and on which date you went back to England?
Malad, I tell you, Lordship.
And on which date you came to depose? What is the miss case for? What is the other miss case for?
Well, this is a case, Malad.
The miss case.
Miss case.
What was the miss case for?
Malad, I have the printout copy of this.
What is the miss case for?
Miss case to Malad, miss case is somehow, Malad, arising out of this. Malad, I don't have any knowledge. But Malad, here what happened? She came, she deposed, and Malad, it was adjourned in 2023. It's not about recent. It's about 2023. She appeared. And then
what is the suit for?
Suit for is a declaration and injunction. Declaration that the occupation of the defendant is illegal. That is the main prayer in the suit. It's at page 43. The degree of 43 delivery of cancellation of such instrument document evidencing any arrangement. Such and
Plaintiffs are
such
the
de-
petitioners.
Hmm?
Plaintiffs are the petitioners.
Plaintiff are the petitioners. Plaintiffs are the petitioner. My lord, I am going to show my lord two things, my lord. First is, my lord, kindly look at
What is the name of the constituted power of attorney holder?
is Aparajita Sharma. She is also the plaintiff.
Aparajita
Sharma,
who is Pranab Bose?
who has filed the plaint on my behalf. She has the Pranab, she filed the suit on my behalf. He was the attorney at that point of time.
Yes.
Attorney cannot depose.
No, no, no.
Plaintiff has to come. So the
Well-
plaintiff is here. Plaintiff number 3 is the applicant. Plaintiff number 3 is the applicant. Aparajita Sharma. Lordship sees the plaint. 21 is the plaint. So there are 3 plaintiffs. Banani Sharma, Jaideep Sharma, and Malad Aparajita Sharma.
Yes.
And Malad, at that point of time, this Mr. Bose was given the authority to file the plaint. But Malad, here ultimately, Malad, it is the plaintiff who has to depose, and she came. And when she came, Malad, this happened, Malad, it was adjourned in a Mies case. Thereafter, Malad, Malad, kindly have a look at Malad page 101. 101 is, Malad, that she is a solicitor in England at page 101, and she happens to be now a British citizen, that you will find at page 99 and 100. Page 99, that is the passport.
Plaintiff number 3 is the registered power of attorney holder of all the plaintiffs.
All the plaintiffs.
And this
Even
Pranab Bose is also the power of attorney holder.
No. Power of the Pranab.
Show me the power of attorney of both Pranab Bose and this.
Power of attorney I have disclosed.
Yes.
At Malad. Kindly come to page 50.
50.
Pranab Bose is the power of attorney holder
of all.
Of
Of
all.
all. And plaintiff number 3 is also the power of
No,
attorney
power
holder.
of she is not the power. I made a mistake. Plaintiff number
Order records that.
Plaintiff-
Order also records that. Plaintiff has filed the instant petition stating plaintiff number 3 is the registered power of attorney holder.
Maybe
How many power of attorney holders you have appointed?
No. The plaintiff, Malad, it is the plaintiff who has to depose, Malad.
Show me the application which you have filed.
Application.
Yes.
Application is at page, Malad, 94. 94 is the application. Malad, even if Malad, forget this portion, as a plaintiff, I have a right to give evidence. I have a right as a plaintiff. So, Malad, I filed an application. Malad, kindly have a rule, Malad, the rule framed by this Honorable High Court, which I have annexed at page 102. If your Lordship kindly take. And I have the judgments even before that was allowed. কিসের অর্ডারটা আমি অ্যানেক্স করেছিলাম কোথায় এই তো লাস্ট পেজ আছে দিস কেসটা কি আর দিস কেসটা কি may I place the rules of this Honorable High Court, Malad?
Please show me the power of attorney of Pranab Bose.
Pranab Bose is at Malad. At Malad, page Malad, Lordship will find page 50.
50.
50. Power of attorney. The power of attorney, page 54, was was done before the High Commission of India in London.
Yes, this was in favor of
Pranab Bose.
Pranab Bose.
Because at that point of time, no one was available for filing the suit. Power of attorney was given to him.
Yes. Now, please show me the power of attorney of the plaintiff number 3.
Well, at that we have not annexed. But the fact is, well,
please produce the power of attorney.
That I will do. Well, kindly one thing. As a plaintiff, well,
Mr. Nag, please produce the power of attorney. For reasons I am asking you, please produce the power of attorney.
well, even well, just for my sake, well, if well, I am a plaintiff.
What is there in the power of attorney, Mr. Nag? Please produce the power of attorney. Then I will hear you. Ashun.
Till then, well, if the proceeding of
No, no,
goes on, well, I am the plaintiff. I am seeking.
You produce. Maybe you are the plaintiff. That does not give you a right to prolong the proceedings.
No, I don't want to prolong it, but.
So when can you produce?
Hey, power of attorney kache ki? But I don't know whether the client is residing in London, how much time will take whether to take the power of attorney. Because we are the lawyers operating from here only. It can take some time. That's what I am saying. That's what I am
this
saying.
petition has been filed by one
thing,
constituted power of attorney, and for deposition, another power of attorney holder sued by another power of.
One thing.
Let me see.
One thing.
When can you, in the email and other things, it can be sent from London. Now days have changed. Does not have to travel through post, so you can get it. How much time you want to?
All I am saying with that. Well, here I am the plaintiff. Even if I have
Nag, Mr. Nag, I will hear all your submissions. Please produce the power of attorney. When can you produce the power of attorney?
Well, it can't be granted me 2 weeks time.
By the order impugned. Yes, next.
41, I am for the petitioner, my lord. But here, my lord, one appeal under section 9 of the Unauthorized Premises Act was filed before
section 9 of
Unauthorized Public Premises Eviction of Unauthorized Occupancy Act 1971.
Yes.
Before the learned Howrah Court of Howrah against the order passed by the Port Trust under section 7 of that act.
Yes.
That appeal was admitted.
Yes.
And order of injunction was also passed by the learned district judge, Howrah. All of a sudden, my lord, in September 2022, the appeal was transferred to an additional district judge.
Appeals to dismiss for default.
Yes, my lord.
Then what happened?
My lord, I made an application under section 151 contending inter alia that the order is nullity as because the order passed by the additional district judge, first track court, who has no authority as per section 9 of the Act 1971. Because Act section 9 of the Act 71 says that the appeal is to be preferred against the district judge or any other coordinated judge having 10 years practice as district judge. So, my lord, this additional district judge, first track court is only 2 or 3 years practice. But he has,
You have stated that?
yes, my lord.
Where is
In
that?
that application, I have stated that.
Where is that application?
My lord, page 40.
So appeal preferred by whom?
Appeal preferred by the licensee.
By your client?
Yes.
So initially the appeal was preferred before the district judge.
Yes.
It was transferred to the additional district judge and thereafter it's to dismiss for default.
Additional district, yes.
That application for recalling was also rejected.
Yes.
By the order impugned.
This is for application for expeditious disposal of the suit number suit 297 to 2014. It is suit for declaration and permanent injunction. Here the applicant is the defendant number 1 in the suit. He is the handicapped person.
What is the stage of the suit?
The stage of the no deposition yet been already written statement exchange. This stage is over, but the no deposition has yet been taken.
This application under Article 227 of the Constitution of India Within is difficult. Substitution, order 22,
Give
rule
the,
4.
give
There
the
are
wrong
7.
date, my lord.
There are 7.
Otherwise, that you will remain pending, my lord.
It's difficult.
Eh, well,
Fixing time is difficult.
1 year should be given, my lord.
You will be finding in that court, in all suits, there's a direction for expeditious hearing. So it will proceed in its ordinary way. The way these expeditious hearing applications are filed, you will be finding in all suits there is a direction for expeditious hearing.
So, giving
So
time.
the court judicial officer will now proceed in ordinary way. No expeditious. Yes.
Well, in this matter, Lordship, I am for the petition, Lordship. Lordship, I just take the liberty of your Lordship to withdraw and file afresh because what I find from the imping order, this is my order 9 rule 13 has been dismissed in eviction suit. I am a judgment debtor.
What has been dismissed?
My application under order 9 rule 13 for setting aside of the ex-party decree against me, I am in the eviction proceeding, Lordship.
Has been dismissed.
Has been rejected.
Yes.
On the score that there was a delay and that delay has not to be condoned. But unfortunately, Lordship, the trial court has not seen that the delay was already condoned in 2020. That order is there on 22nd March 2021. Now that order I have not annexed with this application, I have missed that, Lordship. Number 2, if Lordship may kindly see the imping order on page 8, the court has again embarked on the point of the services of the summons, all those things, which was also found by the predecessor of that court, that the service was unsatisfactory. And so there was direction upon the plaintiff to go for order 5 rule 20 paper publication. And after the notice, we have appeared. Now, these are the findings which I have to annex with my application, Lordship. So I'm just praying for a leave to withdraw and file afresh with all those certified copy, Lordship. Delay has already been condoned in 2021. Now the court finds, if you kindly, Lordship, you kindly see.
What is the suit for?
Eviction suit. Eviction suit.
So if order 9 rule 13, even if I accept, section 5 was allowed, the miscellaneous case dismissal is an appellable order. Miscellaneous appeal.
Lordship, here it was dismissal, but the point of dismissal only.
Whatever it might be, an appeal lies.
Lordship, 913 is to set aside the ex-party degree, Lordship. Now I have tried to show that even the paper publication was also not done properly.
You are challenging on merits.
On merits, but,
so
but
merits,
other points.
Whatever points are there, dismissal of a miscellaneous case under order 9 rule 13 and appeal lies.
Lordship, let
appellable order. So you prefer an appeal? You wanted to withdraw, that is why I pointed out. Again, filing 227, again you have to take leave. That is why approach before the appropriate forum.
That is the what I find from the order 43, Lordship, shouldn't be that, Lordship. But the thing is that this finding is also apparently.
That's on merit. You can assail that in the appeal. You again 227, the same fate.
So again, I have to go back like this.
That is why I pointed out. So what do you want? You want to withdraw to approach before the appropriate forum?
Lordship, then grant me that liberty also, Lordship.
After some argument, the learned advocate.
For declaration of title and permanent injunction. We are the plaintiff.
Please use the microphone.
We are the plaintiff. Now, we are the petitioner. We are the.
What is the order under challenge?
Last page. Below your clarity. For add as a party, this plaintiff, 2 persons belong for disposal of the suit because
order 1 rule 10 rejected. Your application under order 1 rule 10 rejected. What is the suit for?
I'm for the suit for declaration of title and permanent injunction.
Suit for declaration of title and permanent injunction.
I'm for the plaintiff. We are the plaintiffs. But we are the plaintiffs. But two names has been has not been added in the plaint. Now these two persons I find an application kindly see the name, the Manoj Rai and Tapusi Rai. These two persons will be added as the plaintiff because they are disturbing. They obtain patta, land was declared as vested and one plot. Now they decide disturb with the entire property. Now also this
Where is the application under order 110?
Page 44. Page 44. P4 This is application order 110. These are application. Two persons, last page next page 45. The two names, Manoj Rai and Tapusi Rai. They obtain patta. One is respect of one plot. There are several plots. This one plot they obtain patta because land was declared vested. I also one of the plaintiff obtain patta. Now this is for the one should be decided because these are declaration of title. These names should be added. But only. I'm nothing else. These two persons should be added as a plaintiff. One plot they obtain patta because the land declared vested. One petitioner also obtain patta. This is difficult. For the declaration of title, these two persons should be added because they are discharged. Nothing else. The plot number plot number 4578 Bastu elements of them.
What was the cause of action for filing the suit?
They are disturbing the disturbance the private party. They have no right. They already disturbing the plaintiff P1 page 17. This is plaintiff of the suit. Page 17.
Please give me a
page
minute.
17. Page 17 P1.
Please give me a
the
minute.
plaintiff of the suit. We are the respondents. ষষ্ঠ সাব্যস্ত মতে ইনজাংশন দখল কায়েম ইত্যাদি প্রার্থনা দরখাস্ত নালিশি ভূমাদিতে ইতিপূর্বে অধুরা নিত factories they are disturbing the private respondent, they are disturbing the peaceful possession of the plaintiff and these two persons he obtained patta illegally one plot. Means one plot. Several plots is my college. There are several plots in question. তপশিল সম্পত্তির বিবরণ page 30. Several plots. This is declaration of title and question title. But one plot has been declared as vested, and that plot number 4578 passed to 11 districts. Page 41. Page 41. Page 41 was declared vested. So this person, two persons should be added as a plaintiff. Nothing else. The Tapusi Rai and his husband Manoj Rai. Part has been granted. Now page below, answer P3, 43. Several dispute between the plaintiff and defendant. Now the two persons they are obtained patta in this at one plot. But they have now has not been added as a plaintiff.
No, you have not stated as to how their presence is necessary. You have not stated rightly.
And the application the already patta is.
Yes, I have seen the application.
My lord.
Application there is nothing.
Already one of the plaintiff
by the order
by way deed, as if lordship the entire property of the vendor has been transferred. Now I file an preemption application on the ground of adjoining landowner. The preemptee came and took the plea that entire share has been transferred. Now on the verge of argument, it was detected that the vendor has other property in the suit plot. I filed an application for amendment. That has been rejected. Without that pleadings, lordship, inserting into the lordship that application, that entire property has not been transferred, there are other lands of the vendor of the preemptee, the proper adjudication, lordship, will not be possible for the lordship.
Other lands of the preemptee I could not follow.
Kindly consider, lordship, that page 16 of the lordship written.
What is the impugned order? 11th of May.
11th of May.
Take your seat. Please take your seat. Yes, where is your plaint?
Plaint, lordship, kindly comes to page 10. Prior to that, lordship, kindly comes to lordship the deed 122.
Deed I will come after. Please show me the plaint.
Plaint kindly comes to lordship page 10.
Yes, where is the proposed amendment?
Now, lordship, kindly comes to the lordship written objection, paragraph 6, page 15.
Page 15.
Page 15, paragraph 6 onwards, lordship. Is the plea taken by the lordship preemptee opposite parties that the entire share has been transferred?
Yes. Yes, where is your application?
My application, lordship, is at page 17, lordship. That due to lack of knowledge, I could not bring those facts. At the time of argument, lordship, I came to know the fact that there are other land of the lordship vendor of the preemptees.
At the time of argument, Mr.
But Lordship, it was their plea that the entire share has been transferred. On the basis of the Lordship, the false implication by the Lordship, preemptive Lordship, the application was proceeded. Now, this was not under the knowledge of the Lordship petitioner. And this point is Lordship required to be brought, Lordship, unless for the proper adjudication of a preemption application, whether the entire share has been transferred or not, if it is not brought on the record, Lordship, then
Even if the entire share has not been transferred, preemption lies.
now they are pleading is Lordship the entire
Share, Mr.
Now learned.
According to you, there are other co-sharers in that.
No, the vendor of the preemptive, that the Regia BB and Lordship.
Yes, the
Nozrul
vendor of the
Sheikh's
preemptive had other shares. He has not transferred the entirety.
share.
So even if it is not transferred in its entirety, then also preemption lies.
Preemption lies,
So-
Lordship. But the entire share point with the
Not
demarcation,
necessary. This is not necessary.
they have demarcation. Now, entire share with demarcation, the learned court proceeded with the basis, and we also, Lordship, proceeded with the basis, Lordship, the entire share with demarcation has been transferred.
This application under
Is the explication of the temporary injunction, which is pending for the last 2 years, my lord.
expeditious disposal of
Temporary injunction application, my lord.
what is the next date fixed?
23rd, 23rd November.
This application under Article
lost of records.
Yes, next. Yes, who is appealing? Pass over next.
48 AP for the petitioner, my lord. The defendant in the suit for partition, order 7 rule 11 rejected. The plaintiff admits ouster. The plaintiff admits ouster, does not seek recovery of possession. Kindly says, my lord, page 15, paragraph 11 of the plaint.
Decided in the at the time of trial, Mr.
No, she says, kindly sees. She says, be it stated here that after the death of the husband of the plaintiff, the mother-in-law and defendant 1 and 2 used to torture the plaintiff both mentally, physically, in-laws house. They forcefully oust the plaintiff from her in-laws house on such and such. Under compulsion, the plaintiff moved to the parents' house in such and such. Ouster. And then sees the prayers at page 16. Only preliminary decree, then final decree. Account commissioner, decree for accounts.
Where is the plaint?
Plaint starts at page, plaint starts at page 12. And the relevant portion would be paragraph 11 at page 15. She alleges ouster.
So, Bordon, you cannot get more than your shares. So, in the final degree, your possession will only be.
But at the end of the day, there's an ouster alleged, so that even if she succeeds at trial, the ouster will be proved. If there's an ouster,
then what will be done? Suit will be dismissed.
She has to seek for recovery possession. That is, she's not claimed. As of now, the plaint doesn't say that. Number one. Number two, there's a issue on court fee. Court fee I will not be pressing for the present. But this ouster, she has to meet this requirement. Seek for recovery.
Recovery means court fees. You are saying very easy way.
No,
not on the court fees.
The court fees
Ask him to pay for recovery.
No, why
recovery
not?
Recovery will be.
No. Why
will be there.
Why not on the court fees? I'll tell you. Because what happens is that the court can ask her to pay, and then she can make good the court fee. Because Order 7, Rule 11 might not be attracted for the non-payment of court fee at the first instance. But so far as the ouster is concerned, I say the suit is barred insofar as no recovery possession has been sought for. Because she alleges ouster. And it's clear, it's clear from this paragraph 11 itself. She says she's been ousted.
But in a partition suit, possession of the co-sharers are presumed.
Till that time, except constructive. Till that time, a plaintiff alleges ouster. Till the time of
yes, ouster means not in that sense. From the matrimonial home, you have thrown her out.
No, so she says she has left the house.
Yes,
for whatever reason.
House
for whatever reason.
Torture.
For whatever reason, So, but at the end of the day, she has to seek for recovery possession.
Your title with regard to adverse possession and other things.
I am not even an adverse possession. I see.
Ouster, when it was the claim of ouster, when?
Kindly sees B stated paragraph 11. 14. They forcefully oust the plaintiff from in-laws house in 2014. And this is a suit of the year 2025.
After all, Mr. Bordhon, it's a fight between the inside the family. Who are you? You are the mother-in-law and the brother-in-law.
Yes. No.
One of your brothers. Yes.
Daughter and sister-in-law. Daughter and sister-in-law.
Daughter and sister-in-law. Yes. Daughter, sister-in-law, mother-in-law also. No. Brother-in-law also.
Yeah, brother-in-law.
Yes.
Brother-in-law kothay? Taposhi, Manoshi, and Shubhangi.
Taposhi,
Manoshi, and Shubhangi.
All are the sisters-in-law.
Both are one and two are sisters-in-law.
Yes.
And
your brother has passed away.
Yes.
Your brother has passed away, and you want to.
No, it is not that. But kindly visualizes the suit as framed. Third is the daughter. The plaintiff is the mother of defendant number 3.
Plaintiff is the
mother of the defendant number 3. Yes. The plaintiff is the mother of defendant number 3.
So mother-in-law's suit.
No. Mother's suit against the daughter and the sisters-in-law.
I could not follow. I don't think that's the correct.
Kindly sees strictly by the plaint. Sujata Sarkar, wife of Gautam Sarkar.
Yes.
Sees the defendant number 3.
To whom?
Defendant number 3.
Initially, property belonged to whom?
Dana, Dana. They say Sujata, the plaintiff, becomes.
Ranjan Sarkar, Sudharanjan Sarkar, Suranjan Sarkar were the joint owners.
Yes.
So they became, by virtue of the aforesaid purchase, Dilip, they had 1/3 share. Suranjan died intestate, leaving behind Vishwabijay,
Vishwabijay and Digvijay. Wife Mala, 2 daughters Shompa. Dilip transfers. Vishwabijay, so and so, they also transfer.
Thereby, he had 2/3. Vishwabijay, Digvijay, Mala Sarkar, 1/3. Sudharanjan became the absolute owner. Then
Sudharanjan's son Gautam
left behind his wife Shikha Sarkar.
Yes.
One son Gautam Sarkar, 2 daughters Taposhi and Manoshi. Yes. Shikha Sarkar.
So Taposhi and Manoshi are the sisters of Gautam.
Yes. One son Gautam and 2 daughters Taposhi and
Manoshi. Taposhi and Manoshi happens to be the defendant number 1 and 2. Gautam's wife is the plaintiff. Gautam's daughter is the defendant. Number 3.
The date of Sudharanjan is aforesaid. Yes. So
Taposhi and Manoshi are the sisters of Gautam.
Shikha Sarkar. Where is Shikha? Shikha has not been implemented. One son Gautam Sarkar and 2 daughters Taposhi and Manoshi. After the date of Sudharanjan.
Shikha dies, paragraph 10, Shikha dies in 2015.
Oh, Shikha dies.
Yes, 2015.
Yes, so now it's between the sisters-in-law.
Sisters-in-law and the daughter of the plaintiff is defendant number 3. So daughter of the plaintiff is defendant number 3.
Yes.
So it's basically mother versus daughter and the sisters-in-law.
Yes. Shubhangi is the daughter of Gautam Sarkar.
Yes, and kindly sees the plaintiff is the wife of Gautam Sarkar, Sujata.
So Sujata is claiming how much?
1/8. That would be page 9, page 15, para 9. Sujata becomes joint.
This Sujata and so 1/3 Gautam, Taposhi and Manoshi will have 1/3 each.
I strictly go by the plaint, paragraph 9. Sujata 1/8.
All right, come tomorrow.
Tomorrow, Monday. Grateful.